6th century Ireland, there was a chap called Columba. He was an abbot. He went on to become a saint, but in the 6th century he was a missionary. He was an incorrigible plagiarist. He was famous for it. He was famous to such an extent that there's one story that there was an abbot who was so concerned that he was coming to visit the monastery that he took all the books and buried them in the orchard. And Columba was so upset about that he put a curse on the monastery. One of Columba's tutors was another soon-to-be canonized abbot called St. Finian, and he got really upset when Columba took a psalter, a book of prayers, and laboriously copied it all out and then gave it the original back. He got really angry with that, so he asked the King of Ireland to intervene, King Dermot. Now, King Dermot didn't know what to do. There was no law on this subject, but there was a law of theft which had got quite developed, and there was a principle in the law of theft, which is as to every cow its calf. Now, what that means is that if you've got a cow and your cow is pregnant and your cow wanders off into somebody else's field and calves in your neighbour's field, the calf doesn't belong to the neighbour, the calf belongs to whoever the cow belongs to. So the owner of the cow owns the calf. He took that principle and he said, well, as to every cow its calf, as to every book its copy. And on that basis, he said that the copy of the book belonged to St. Finian rather than St. Columcille. And in so doing, he created the first piece of intellectual property law. Now that's 1500 years ago. What I find is incredible and quite frustrating is that when you look forward 1500 years, very little has changed. What King Dermot did was he looked at the original prayer book, then he looked at the copy, he compared them, and he said, that's a copy of that one I'm giving at, so that's an infringement, and I find in favour of the claimant. Nowadays, what's odd is that when is copyright in software is dealt with in exactly the same way. And for that reason, you don't really get any software copyright cases. What happens is if you bring a software copyright case, the judge will take the code. If you scroll up, there's a.
Now you're gonna have to scroll with the mouse. Yeah, 2-finger scroll.
That's it.
There we go.
So, as you probably know with code, when you've got a program, there's multiple ways that you can make the program do exactly the same thing using different bits of code. But if you want to bring a copyright claim, all the judge will do is, just like King Dermot, he'll look at the one code and the lines, and if they're the same as the other, he'll say there's infringement. If they're different, he'll find no infringement, even though actually the code does exactly the same thing. That doesn't matter. Copyright only protects an exact copy of the code, which is quite frustrating. That's a very long way of me trying to apologise for copyright, because it is unfit for purpose. It's a principle that's been added over 1500 years in a very slow fashion. It's not kept up with technology, so it's a very imperfect way of dealing with quite complicated intellectual concepts, such as print, such as technology, such as the internet, and anything online. Okay, so that's my apologies out of the way first. So let's start by saying, what is IP? Can I have the next slide down? These are all funky slides, which happiness, is good for your soul. Therefore, but the primary reason is actually the economy. Is that IP drives an awful lot, certainly of contemporary British economy. It's a huge driver of the economy. So the law steps in, and the law says that, well, we want to encourage creativity. One way that we can encourage creativity and incentivize it is to give people an element of control over the fruits of their creative labour. At the same time, And that will encourage people, when they've got that control, it encourages them to use that control to, for example, make money out of their fruits of their labour. At the same time, all of intellectual property has that part of it, but it's also got another part, which is that society doesn't benefit if you create something and then sit on it. So there's always some defences which enable people to make some use of the fruits of your labour, even if you don't want them to. So there's always this balance to be struck between the interest of incentivising creativity and the interest of society in having access to important works, important inventions, and that sort of thing. Okay, 3 different categories of things here before we get to copyright. Patents historically was regarded as the elder statesman of intellectual property, and certainly when we were a manufacturing industry, it was, and it's still a big driver of the economy. It's pharmaceuticals and it's engineering. But actually, if you look at the statistics, we're no longer a pharmaceutical, we're no longer a manufacturing economy, we're actually more of a creative economy, we're more of a copyright economy. But certainly, received wisdom until at least 15, 20 years ago was that patents were the big drivers, and certainly in periods of British history, huge drivers. Patents is a 20-year monopoly on a 15-year monopoly on an invention, and it needs to be inventive, non-obvious, and not prohibited, and you have to register it, and in the country that you want protection, and if you register it, let's say in the UK or America, then you get protection in that territory, and anybody else that uses the same technology, whether they're copying you or not, can be stopped. The rub is that if you want a patent, you have to disclose how your invention works down to the tiniest detail, and that gets publicised, it gets put onto a public register, and the idea is that just enriches public knowledge, but in return you get a monopoly on it. So if you've got a secret, if you've got something like a recipe that you can keep secret, there's certainly no need to get a patent. You simply keep it secret. So recipes like Coca-Cola or Kentucky Fried Chicken, they could have got patents, but they never did, because patents they would have had to have disclosed the recipe, then they'd have got a monopoly for 20 years, 15 years. As it is, they've got a perpetual monopoly as long as they can keep it secret. If you'd have seen the slides, there were things like the elastic band, the paper clip. These were all patents at one time. Certainly the locomotive engine was a patent. More recently, things like you get lots of technology patents, and then things like the Dyson cyclone technology. These are all patents. And what you find is that when the patent comes to an end, people jump in, and then you get the generic. And that happens a lot with pharmaceuticals. Pharmaceuticals get a patent. Patents come to the end, like big patents come to the end of their life, like Viagra, and people just jump in, create generic. And they can do that very, very easily because the recipe is sitting there on the Patent Office website. Trademarks, the animations have things like the Apple logo, the Apple name, the Nike swoosh. Those are conventional trademarks. Names and logos are trademarks. You can register them, and you can get, and again, on a territory by territory basis, you get a monopoly on the use of those trademarks in respect of defined goods and services. But it's more than just words and logos. You can register things like smells. You can register sounds. That ding 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 ding. You know, the Intel. That is a trademark. They've had to register it. They've registered it with the notation, and that is a registered trademark. Nobody else is allowed to use that sound in respect of computers. Just like the Microsoft on, the Brian Eno sound, that's a trademark as well. And then some smells are. There's weird smells, like the smell of beer as applied to a throwing dart is a trademark. These are tricks that trademark lawyers do in order to show off how clever they are. They register these weird, the smell of cut grass as applied to a tennis ball is another one. I'm not aware of any practical smell marks, but conceptually you can have a smell mark. You can register a colour. Cadbury's have got the colour purple registered for chocolate. Orange telephones have the colour orange registered for telecommunications. You can register colours. That's the registered regime. Alongside that is what we call the unregistered regime, passing off. And what I've got there is the GIF lemon. That's one of the most famous passing off cases. Reckitt and Coleman at the time did their orange juice in a lemon-shaped container. Still do today, the GIF lemon. Asda sold their generic their lemon juice in a lemon-shaped container. It confused people. People were clearly putting the Asda lemon into their shopping basket, thinking they were buying a GIF lemon. And that combination of goodwill and confusion on the part of the customer and damage on the part of Reckitt & Coleman resulted in a trademark claim, even though they didn't have a trademark. So there's two regimes. It's much harder to bring a passing off claim, but it's there and it runs parallel to the registered trademark regime. And then last, quickly, I've put up designs. Designs protect the shape of a thing. So the Philips Stark juicer there, it's not an invention. Juicers had always been there. It's actually a very bad juicer, but it's a beautiful thing. And the shape of that beautiful thing is protected. And there are multiple ways in which you can protect. There's an automatic, some designs qualify for an automatic 15-year protection, some qualify for an automatic 3-year protection. Others, you can register and extend that protection for up to 25 years. But you're not a design business, so I wouldn't worry too much about that. You are a copyright business. So we can scroll down to the next screen. What is copyright? This is from a 2001 decision, actually. This is the law copyright rests on a very clear principle that anyone who by his or her own skill and labour creates an original work of whatever character shall, for a limited period, enjoy an exclusive right to copy that work. No one else may for a season reap what the copyright owner has sown. In an abstract level, it's a time-limited right to prevent the copying of certain categories of work. And I think it probably makes sense if we just skip on to the next slide, because it all makes sense when you start to look at examples. Copyright, the legislation breaks down copyright into different categories of work that qualify for copyright. So these works, to the extent that they are original, and we'll come on to original in a moment, will qualify for copyright. So what we have here is literary works. This is the important one for you. Literary works, text, if it's original, will qualify for copyright. So literary, dramatic works. What have we got as my dramatic? This is a book, and the Roald Dahl book is subject to literary copyright, but the stage version of Charlie and the Chocolate Factory is also triggers a separate copyright belonging to the producer and the screenplay writer of the play. But the play infringes the book, so you can't create the play without the consent of the author. The reality is that on a product like this, this is a commercial product, Charlie and the Chocolate Factory will also be a registered trademark as well. They'll protect it in as many ways as possible. Certainly when we come onto things like The Hobbit, there'll be extensive rights. So literary, dramatic, musical works. So again, the interesting, what you end up with copyright. Literary copyright is interesting because it's the simplest. Other copyrights get very complex. So musical copyright is pretty complex because when I say music, I'm talking about the music itself rather than the lyrics. So with Sgt. Pepper there, there's separate copyright in the lyrics, and they're Lennon and McCartney, or Lennon or McCartney. And then there's the musical composition, which is actually a band effort with George Martin. So, and it's the music, and music is separately protected from literary works. So, literary, dramatic, musical, artistic. So, paintings, photographs, sculpture, and what we call works of artistic craftsmanship, again, is a separate head of copyright work. What all these have in common, you can see, are that these are the works of artists. But before, with we were talking about engineers and chemists. These are all artists in its widest form. Artistic works, sound recordings. So the famous Jonathan Russell Brand. What they said was a literary work. So when you speak, and those words are either transcribed or recorded, then there's a literary copyright in those words, but there's a separate copyright in the recording of those words.
What about text to voice?
So
like with on Kindle, you can have where there's an automatic thing that you can change. The text is done by an automatic voice.
That raises an awful lot of interesting questions
let's not go there
about computer-generated copyright.
Yeah, okay, let's not go there.
But let's
not go there.
Film. Now, film, again, I've chosen a film based on a book, just to show the levels of IP in here. So the Hobbit, of course, is a Tolkien novel. The film is a Peter Jackson. It'll be New Line Cinema, whoever it is will own the rights. The rights in a film belong to the director and the producer. They share the rights. The reality is that the directors and producers will sign away their rights to the studios, but the basic principle is that the director and the producer will have shared rights in a film. But of course, that film also involved a literary work. It also involved music, and it also involved trademarks. When you've got a huge product like that, you bundle together as many rights as you can to create a package that is protectable and exploitable internationally. What else have we got? Broadcasts. So sound recordings, just like sound recordings, broadcasts at the end, TV broadcasts are protectable separately from the film, but a simultaneous sort of broadcast is also a protected copyright work. And then finally, typographical arrangements, which is relevant to you, because what we're talking about is patents and trademarks, they're monopoly rights, but copyright isn't. Now, what does that mean? Famously, it came up in a music case involving George Harrison, which was that he wrote a song. Years later, or shortly afterwards, a claim was made against him by I think it was a Hungarian composer, a Hungarian pop star, who said, "Well, look, this tune is identical to my tune," and when you listen to it, yes, it was pretty much identical. But when they looked into it, it was a tune. It was written in Hungary. It was played on the radio 2 or 3 times in Hungary, but it never had an international release, and it was never heard anywhere outside of Hungary. And George Harrison was able to show that during those few weeks that it might have been played on the Hungarian radio, he was nowhere near Hungary, so he wouldn't have heard it. So he was able to show that yes, it's the same, but I didn't copy it. It just happens to be the same, and that's fine. That's not copyright infringement, because copyright isn't a monopoly. Contrast that to trademarks, where if you were to say, well, I've just built this piece of computer software, I'm going to put an Apple logo on it, I've never heard of Apple before, that won't work, because Apple have a monopoly on the logo, whereas a musician only has a right to stop copying. And you may see there's a big case rumbling through the courts at the moment involving Led Zeppelin and Stairway to Heaven. That's all about that will succeed or fail on the extent to which the claimant can show that Jimmy Page had heard that earlier song and was subconsciously influenced by it when he wrote Stairway to Heaven. There has to be a copying element to it. So how do you infringe copyright? Well, copyright is infringed if all or a substantial part of the work is copied. So all is easy. So if you do a photocopy of a book, then of course you've copied all of it. What does substantial part mean? And really unhelpfully, and this is why everybody hates lawyers, it's a really difficult thing to say. It's not a quantitative test. So it's not you can use up to 10% of a book. Sometimes people tell you, oh, there's a sort of a 2-line rule or a 3-sentence rule. There's no such thing. If you've got a poem which is 3 sentences long, and you use 2 sentences, that's going to infringe copyright. If you've got a 1-line poem and you use 4 words, that could be a copyright infringement. There's a whole load of factors that you have to look at, and unhelpfully, there's no. It's what we call a qualitative test rather than a quantitative test. You have to look at the whole thing and decide whether or not you've taken a substantial part of the whole. And it's not, and it could be that you've got a novel and you've taken a sentence, but it's the key sentence. It's Tale of Two Cities. It's the opening line, and because that's so evocative, then that probably would be if Dickens was still in copyright. We can flip on. How long does copyright last? Copyright lasts for 70 years following the death of the author. And the peculiar way it works is that regardless of when the author dies, copyright will expire on the 31st of December at the end of 70 years after they die. So hot tip, if you're going to die, try not to. If you're going to die at the beginning of the year, because then you get nearly 71 years worth of copyright. Now, so what that means is that the 1st of January works come into public domain. Now this year was an interesting year, January the 1st, 2016, because if you go back 70 years, that's 31st December 1945, which was when these two important authors became public domain. So Anne Frank and Hitler, and there was a lot of talk about the Mein Kampf copyright. In fact, the German government was really anxious about it. They were going to rush through legislation to extend the copyright, so that, because the way it worked is that copyright was by statute assigned to the government, so the government could control and clamp down on publications of Mein Kampf. And there was a thought that, well, that's what they better lock it down to stop people from reading it. But actually, they never did in the end. And I think you can get Mein Kampf now. I think it's probably a good idea. Otherwise, it just ends up with a mystique and aura that it doesn't deserve. But interesting at the same time, of course, Anne Frank is out of copyright too, on the same day as Hitler's work in copyright.
Anthony, sorry, question on that. With the Anne Frank, interestingly, because there's a Anne Frank family or trust or someone who's fighting this, saying that
they were trying
they
to
didn't actually finish the book until it had been fully revised many years later than first published.
You're right. There were arguments later on that yes, that the family took those works, and it wasn't simply Anne Frank. There were all sorts of additions. I don't know where that argument got, but
I think it's still pending. I'm not sure. But maybe people are potentially publishing anyway.
Yeah.
Until it's clarified 20 years from now.
There are. That remains a controversial story. That whole Anne Frank story. I've put down territory here because all intellectual property rights are national in their scope. So a trademark right, if you want trademarks, you have to register them country by country. One of the beauties of copyright is that through a series of international treaties, the Berne Convention most importantly, copyright is effectively international. There are a few countries that aren't party to Berne, but not many. Certainly nobody in the developed world, and most countries in the developing world are party to the Berne Convention. And what that means is that every party to Berne respects the copyright of other treaty nationals and confers on them the same rights that they confer on their nationals. So if you're British, you can be confident that because Britain and America are party to Berne, your copyright will be respected in the same way in the States that they respect their own nationals' copyright. So copyright is great. It's free, lasts for a very long time, and it's international.
And just in terms of the kind of qualitative element of how much you can or can't use, so my understanding is in the US they use the term fair use. Is that the same, basically the same as substantial part?
No, we'll come to that.
Okay, sorry.
Fair use is a minefield.
That's what I thought. But
and we'll come to that.
Okay,
it's quite fun.
Can I take another quick question
Sure.
on that? So we ran into a bit of a problem actually a few years ago at HarperCollins where we were putting together a very aggressive out of copyright classics system. And we waited until I think it was 2012 when Fitzgerald had died at 70. And we were able to put it out very easily the rest of the world except for the US, who still had a claim on it. Does something like that happen through, again, a foundation, or is it? It was a nest we did not want to broke. It was not worth it for £2.50 8 formats. But how does that happen?
I think what happens because it happened recently with Sherlock Holmes, because Conan Doyle went out of copyright, but there was
only certain books did.
Certain books went out of copyright, but there was it was a trust or a company who argued that after Conan Doyle or during the lifetime of Conan Doyle, they developed the characters, particularly of Watson, and actually contemporary reproductions of the Watson character owed more to the non-Conan Doyle accretions than the original Conan Doyle. So they tried to claim that anybody who uses Watson and has Watson wearing a bowler hat and all these other things which they were able to show were actually never in the Conan Doyle original. They were infringing a different copyright from Conan Doyle. Now that doesn't apply to Great Gatsby, because if you're just printing a faithful reproduction of the original, then I can't see how that could be extended. But it's the nature of American law that if you've got a clever, charismatic lawyer, you can probably concoct some sort of nonsense argument, and if you've got the money, that's it. You just keep it going through the labyrinthine American legal justice system until you lose. But hey, you've got another 10 years when people have been too scared to use it, and 10 years of copyright on The Great Gatsby is actually worth the trouble. So that may be the reason. I don't know.
Like the Happy Birthday case as well, right?
Yeah, all these stories. It's well, coming up. Well, I've got a story which kind of illustrates this point in a minute. If I can scroll down. Does every work qualify for copyright? No, it has to be original. But the bar on originality is really low. It has to be, and it comes down to, has it been copied? And if it hasn't been copied, it's original. That's pretty much it. You can't say, well, this idea is trite. This is a cliche piece of nonsense. You've got to show that that those words on the page have been copied from previous words on the page. Otherwise, regardless of its artistic integrity, it's going to be original. It's going to qualify for copyright.
So does that mean that you can take the idea of the story, like exactly the same, and just change all the characters, change the place?
That's my next slide.
Oh.
So there's a concept of idea and expression, which is there are no rights in an idea. There's no copyright in an idea. There is copyright in the expression of the idea. What does that mean? Well, copyright protects the words on the page. It doesn't protect the concept behind those words. And there's a very old case from 1890 called Kendrick and Lawrence, which was all about voting instructions. So, funny enough, it's still the same today, but certainly in the 1890s you had an illiterate population, a largely illiterate population. So when you were showing people how to vote, you had to have a drawing of somebody putting an X into a box. You couldn't say mark the box with an X because people couldn't read. So you had to have a thing like that. That's not the image, but something like that of a hand drawing an X. Now in Kendrick and Lawrence, you had somebody draw with that image. Somebody else doing a different election didn't copy the same hand and the same pen and the same cross, but they copied the idea of a hand and a pen and a cross. And it went to court, and the judge said, well, there's only really limited ways in which this idea of putting a cross in a box can be expressed. And I'm not giving you a copyright on the idea of a hand and a pen and a cross. What you have to show for infringement is, if you've got an artistic copyright, which is what we're talking about here, you've got to show that the actual art, the actual skill of the artist has been copied, but not the skill of the person who came up with the idea. And that's the principle. I think I'm very safe ground in saying that the mere choice of subject can rarely, if ever, confer on the author of the drawing, and for drawing you can read book or anything else, an exclusive right to represent the subject. Now, this famously, can I take the next slide? This famously was tested in this case from a few years ago, which brings together a couple of ideas actually we've been talking about so far. So this is Watkins, of course you know about the Vinci Code and Holy Blood and Holy Grail, but basic principle of the Vinci Code is the theory that the Holy Grail is a metaphor for the bloodline of Christ that ran through Mary Magdalene down to present day. And it's a thriller. Regardless of what you think about the book, it's sold like you wouldn't believe. It was a huge seller. But that idea of the Holy Grail being that metaphorical bloodline wasn't Dan Brown's. It actually had been espoused many years previously by these guys, Bagent and Lee, who wrote The Holy Blood, the Holy Grail. Now, in a nod to the source of his idea, one of the main characters in the Da Vinci Code is called Lee Bagent. The character played by Ian McKellen in the film is called Lee Bagent. So he clearly was kind of acknowledging. But nevertheless, Bagent and Lee sued Random House. Bagent and Lee, who published Holy Blood, Holy Grail through Random House, sued Random House. Huge publicity, big high-profile High Court case. In the run-up to which, I used to have a screen grab of it, but when you put Da Vinci Code into your basket at Amazon, they'd recommend that you also buy Holy Blood, Holy Grail. So sales of this, which had been moribund for a decade, just suddenly went through the roof. And in the case, the judge he applied the same King Dermot test. He looked at this and well, show me, get your highlighter out and show me where the words are the same. And they couldn't do it. They had to say, well, there's the idea here, and here's the idea again on page 57 of Da Vinci Code. And he said, no, there's no rights in an idea unless you can show that a substantial part of the words have been copied, they're no infringement. So win to Da Vinci Code, but actually win to everybody, particularly Random House. So I said at the beginning that with copyright, you have to balance the interests of the author against the interests of society at large. And there are a number of defences to copyright infringement. There are things that you can do with a copyright work which will not infringe. Now, the first this isn't a defence to copyright work, but I've lumped it in, which is that because I said that you only infringe copyright if you use a substantial part, the flip side of that is if you use an insubstantial part, then you don't infringe copyright. The rest of these are where you use a substantial part. So if you're taking a chunk of work. Now, incidental inclusion is an example. Is where it doesn't come into literary works really. It comes into more artistic works. If I was to stand with Joe sitting there, and then he tells you to take a picture of me, you'd get that art in the background. And if you put that on Facebook, technically, you'd be infringing the copyright in that artist. But that's fine because that's incidental inclusion. That just happens to be in the background. If for some reason it was important and you'd positioned me so that that picture was in the background, it wouldn't be incidental inclusion. That would be a deliberate inclusion, and that would trigger a copyright infringement. If it just happens that there's something in the background, that's incidental and that's fine. That's not infringement.
How do you prove that? Whether it's incidental or on purpose?
Evidence, witnesses, all of that sort of thing. I mean, there have been. So here's the case involves of all things Panini stickers. You know the football stickers. The Football Association sued Panini because they said that for World Cup, whatever it was, '86 or something, they said that the Three Lions is a copyright work. Every single picture of the England team has those three lions on there. And Panini said, well, yeah, but that's incidental. They just happen. That just happens to be the case. Of course they're going to have it because these are England football players. But actually on the evidence, they'd rejected loads of pictures of football players where there was a hand, where they'd moved. They deliberately chose pictures where the three lions was clear and evident. And therefore it wasn't, they deliberately chosen pictures which had it. So for that reason it wasn't incidental, it was deliberate inclusion, and there was a copyright claim there. So was there another question?
That was my question.
Reporting current events, criticism and review. So reporting current events, this doesn't apply to pictures, but it does apply to text, and it does apply to film. Where you fairly use a work for the purpose of reporting current events, you don't infringe copyright. What does fair mean? Again, a lot of factors go into it, but it's got to be fair and reasonable use, and that's why you can get away with interview texts being used. You know, Donald Trump said this, bang, it goes onto the newspapers. He can't use his literary copyright to stop that work going up because it's a reporting current events story. Criticism review. Now this is relevant to you. Again, it has to be a fair use. So where you use and this does apply to artistic works and literary works, where you reproduce a work for the purpose of criticism or review of that work or of another work. So if you're let's say you're criticising a book and you use a picture of a film from the book, that can technically satisfy the test. It has to be fair. So again, you can't have a little bit of text at the bottom of the page saying this film is rubbish and then a huge great big picture of the poster. There must be a sufficient acknowledgement, which means that you've got to say copyright belongs to, or this is a work of. And it must have been made available to the public, so you can't use it as a spoiler. It has to have been made available to the public, and then you can criticise and review it. You can't criticise and review it before it's been made available to the public. Be careful. If you're going to use it, be careful, because it's the fairness which is the tricky thing. But it's how newspapers and magazines. It's one of the principles they use.
So does that mean if, for example, someone was seeing a preview of like a play or a film, and then wrote a review, they wouldn't be able to post the review until it comes out?
Well, it depends if there's anything in the review that would amount to a copyright infringement if you published
like
it.
Like images and stuff?
Well, yes. So stills from the film, you wouldn't be able to do that. Text, lines of text from the film, you would be able to do. But let's say a stage show. Well, that's already been released to the public. So.
How about Star Wars and spoilers?
Yeah, so they would have jumped on those. Yeah. They would have jumped on those, and you can't get away with that sort of thing, particularly with a big budget film like that. They'd have killed you. They'd have had you killed.
Yes.
But I presume that if it's in the if ultimately whatever the usage is, it benefits whoever it is. It's their decision whether they prosecute or not.
Exactly. I mean, actually, with all of this.
Yeah.
So I used to do a lot of work with like Heat magazine and some of the sort of the trashier end of the magazine publishers, and they would invariably come to me and say, look, we've taken this picture from an Instagram account of X, or we've found this picture of Y. Can we publish it? And my answer would be, well, okay, we've been through this before. You know that this is an infringement, don't you? You know that I can't tell you can do it. You know that, don't you? But let's have a look. Let's have a think about this. Who is this? It is Katie Price, or it is Britney Spears. We know for a fact that they live on this this is their oxygen. So they are not going to complain about it. In fact, they love it, because the more column inches they get, I don't know how their business model works, but somehow they get richer. Whereas if it's a picture of J.K. Rowling, or Hugh Grant, or something like that, then don't go near it, because they will. So you're right. You always there's the legal risk analysis, but then there's the commercial risk analysis that you always have to do, and you have to do both. Let's have a look at the next page. This is fun. This is Star Wars comes up a couple of times. This is a new defence we've got. It's the Defense of Parody. It's relatively new, 2014. So let me illustrate it. So quite a while ago now, maybe 2013, I think. This is so before the whole emissions scandal with Volkswagen. Volkswagen did an advertising campaign involving Star Wars, where it was really cutesy. It was little kids running around dressed up as in stormtrooper costumes and things, and then a kid pretends to use the Force on the car door, and inside the house the dad presses a button and it beeps or something, and the kid says, "Wow, I've got the Force." And that was it. It was very cute, and it was a straightforward VW advert for the Passat. What Greenpeace did was they took exactly that, but they added another 10 seconds of footage. So you have all that lovely scene, and then the camera pans out, and the camera pans up into the sky, and it pans onto the Death Star, and then the Death Star has this, it's a fantastic piece. The Death Star has the VW logo on it. And then it came up underneath, VW responsible for X million gallons of emissions a year and that sort of thing. It went up. It was huge for a period of time. Volkswagen didn't do anything. Volkswagen never took any steps to take it down. Lucasfilms issued a takedown notice to YouTube, and it went away. But not before people had downloaded it, and then it suddenly just popped up everywhere. And that's how things remained for a long time. Another example there.
It's a bit, it's a bit what happened with the Jeff Koons case.
We're going to come to Jeff Koons. Oh. I've got more Jeff Koons than you can stick a sticker. So this is Jay-Z and Alicia Keys' the New York State of Mind, Empire State of Mind. These guys, Goldie Looking Chain, did Newport State of Mind. So it was a homage to Newport in Wales. And again, it didn't last very long before the record company had it taken down. But there was a copyright review. There was a review of the law in 2013 when the government looked at these kind of things and they said, actually, this is good for society. We should allow this. And America's always allowed it. You know, people like Weird Al Yankovic have made a career out of doing this, but we've never had a law of parody in the UK. In America, it came under fair use, which we'll talk about in a minute. So 2014, we got a law of parody after this review, which said that this kind of thing, actually it quoted Newport State of Mind and said, this is really good for society. We need this. So in 2014, we got a law of parody, and it's been around, and there has, and I'm not aware of any UK cases, but I'm going to show you how it works, how it's worked overseas in Holland. This is a case from last year, or maybe the year before. So this is the original work, Suske and Wiske, a Belgian. It's in Flemish, published in the 60s. Belgians love these kind of catalogues, these kind of comics, and this was a series of the adventures of Suske and Wiske, two kids, these two kids here. The Wilde Wildonna, I don't know how you say it, translates roughly as the compulsive benefactor. So that was the original work. The author, long since deceased, the rights passed his estate. 2014, this turned up. Now, a couple of things you need to know about this image. Another Belgian image. This chap here is the mayor of Ghent, as you'd know if you were Belgian, because he's like a Boris Johnson sort of level of celebrity. That's the Belgian colours there on his waist. Slightly more sinister down here. All these people, the beneficiaries of the benefices of the compulsive benefactor, hijab wearing, dark skinned, clearly Muslim people. And this is, and in the background, this was a publication by Vlaams Belang, who are these are called Vlaams Blok. They're the extreme right-wing Belgian nationalist party. So the idea was that the mayor of Ghent was throwing away public money on illegal immigrants. Now the rights owners, the descendants of Van der Steen, sued for copyright infringement. Belgium has always had a parody defence, a lot like the one we've now got. And the Vlaams Belang said, no, this is parody, this is allowed. And he went all the way to the European Court of Justice. He went all the way to Strasbourg. And the answer, I think I've got a slide. Can we put it down? So the question was, is this a parody? And if it is a parody, is it the kind of parody that's allowed? Because parody wasn't defined, but it's now defined. The essential characteristics of parody are to evoke the existing work, so yes, that's certainly evoking the existing work, whilst being noticeably different from it, and secondly, to constitute an expression of humour or mockery. So it satisfied the test of being a parody. But the court went on to say, the application in a particular case of the exception for parody must strike a fair balance, and it's the word fair there, between on the one hand the interests and rights of the authors, and on the other hand the freedom of expression of the user of a protected work. So that's the nationalist party. What they were saying here is that you can have a parody, but you've got to balance the interests of the two conflicting parties, and you've got to look at the harm that's going to be occasioned to the rights owner. And they went on to say harm could be an unsavoury association with horrible ideas. In typical ECJ fashion, I mean, what they often do is they're not allowed to make decisions of fact. So they couldn't say this is an unfair use. All they can do is say this is the law. You've got to take into account whether it's a fair use or an unfair use, and then they push it back down to the national courts to have another go and look at the evidence and decide for itself whether or not it's fair or unfair. That's not their job, isn't to look at evidence. Their job is to just opine on the law. So they pushed it back down to the national courts with a very clear indication that if you find that that there is harm is going to be suffered to the reputation, the literary reputation of the original author, then you can find that this is an unfair parody and you can prohibit, you can find it as a copyright infringement. But this is new for us. I mean, we've never had a law of parody in this country, so I think it's worth exploiting. I think that there's opportunities there for parodies which have never been there before.
So what happened with that case?
I don't know. I lost interest in that case. I was thinking actually on the way here I could have looked that up and found out what happened when it went back down to the Belgian courts. I don't know.
Did the authors have the same opinion of the parody or whatever?
No, that's why they brought the claim.
Yeah.
Their evidence was this is horrible, and this will forever tarnish the reputation of my father.
Sorry, you mentioned it wasn't strictly relevant to this, but you mentioned, and it's pertinent to the earlier point about the author and then the author's estate.
Yeah.
So just going back to that, if you're a copyright owner and you're out of copyright, you're dead after 70 years plus after 31st of December,
Yeah.
your copyright can pass to your estate.
No. So what I mean there, so Wildenstein died in 1995 or something. So when I say the estate so he died in 1995, that's when the clock starts ticking, 70 years.
Yeah.
Because he's dead, it's the estate who own the copyright.
Right, so basically, just for complete clarity in my head, irrelevant of whether you've got an estate or whatever, that copyright expires after 70 years.
Bang,
right,
it's dead.
Okay, so right, thank you. So henceforth, estates want to monetize as much as they can within a period of time.
Yeah. I've got a great. Well, if we've got time, I've got a great story about that. Can I tell you my quick story? I love this story. It's about Thomas Hardy. So we, my firm I used to work for, we used to act for the estate of Thomas Hardy. It was a little trust, a little woman who. So the way it happened was Hardy died, left his copyright to his wife. His wife outlived him for a very long time, retired down to the south coast. When she died, the law of copyright used to be 50 years post-mortem, and it was extended to 70 years in the 90s. When Mrs. Hardy died, the copyright had gone. She left her estate. She left the residue of her estate. So she said, my house goes here, my jewellery goes over there. If there's anything left, it goes to my housekeeper. Thinking that the copyright had gone, there was no copyright left. So she didn't mention copyright in the will because there was nothing there to give. But she said the residue of my estate goes to my housekeeper, who's looked after me all these years. A couple of years later, we harmonised copyright law so that a whole bunch of works, including Hardy, including D.H. Lawrence, including James Joyce, all came back into copyright because they were within this 20-year window. It's called what's called revived copyright. So this little old woman who inherited like a couple of little knickknacks suddenly acquired the Hardy copyright. It was really valuable. And the other thing that happens is when a work goes out of copyright, people pile in and start doing films and TV. And once you've created that market, you can't just pull away. So having created the market, the works came back in. They had to satisfy that market demand for film versions and TV versions. So they did, and it was only a period. It was only about 6 years, I think, when it came back in. And we dealt with this estate, so we were helping with the administer the royalties. And each time somebody wanted to do something, they had to get the consent. And there was a version of Return of the Native with Clive Owen and Catherine Zeta-Jones, this was about 2 or 3 years before the copyright was expired. And Carlton TV said, "Can we have the rights?" We said, "Fine." And they said, "Well, we want to do repeats, but of course, after 1st of January, whenever it was, we'll stop. We're not going to pay you anymore because the copyright's going to expire. So we said, fine. So they did it. It was actually quite successful, that TV series. It was a sort of a mini series. And it got repeated a couple of times. The last time it was repeated was over the Christmas holidays, and it was a 3-parter, and it was shown on the 30th of December, the 31st of December, and the 1st of January. And the way that the deal had been done was we somehow managed to get the 1st of January in on the royalties in the way the contract was drafted. So had Carlton delayed the broadcast of that repeat by 2 days, they'd have paid nothing. As it happened, on the last day that the work was in copyright, it generated a little bit of money that went back to little old woman in Sussex. I thought it was a really sweet story. Fair use. Now, we've been talking about UK law so far. US law has very similar to UK law in many respects. 70 years post-mortem. Sorry, when I say 70 years, there's a couple of exceptions. So old photographs are a bit dodgy. Unpublished works, where the works are unpublished at the date of the author's death, there's a slightly different rule. And Crown copyright is a slightly different rule, but they're marginal. It's 70 years. General rule, 70 years post-mortem. And the same in the States. Where we differ is that we've got very prescribed rules about the defences. So we've got criticism or review, we've got our parody, we've got various educational uses, which I'm not going to bore you about, but examination use, all these uses. In America, they don't prescribe their defences. They simply have a defence of fair use, this is in the Lanham Act, whatever it's called, is the Copyright Act. The fair use of a copyrighted work, including such use by reproduction of copies in phono records, it gives you an idea of how old this piece of legislation is, or by any means specified by that section, for purposes such as criticism, comment, blah, 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 is not an infringement of copyright, but it has to be fair. So they've got this very general rule, and then they've got lots of judge-made law about what is fair. And there are these factors. There are 4 factors which determine whether or not a use is fair. The purpose and character of use, including where such use is of commercial nature, is for non-profit educational purposes or is transformative. What does that mean? Well, you've got to look at the nature of the work. If you're using it for a purpose which is blatantly commercial, you're simply ripping off the work in order to make money, then it's unlikely to satisfy that first test. But transformative is a really interesting word, and we'll talk about what that means. The idea behind that is, well, if you take a piece of art and you create a completely different piece of art you take a book and you can create a completely different book. Or you take a song, you take a sample, you can create a completely different song out of it. If you can show that you've transformed it into a completely different kind of work, you can satisfy that test. The nature of the copyrighted work, what that means is that what they say is that if it's a really creative piece of work, like a novel, you get a higher level of, it's more difficult to claim fair use than if you're writing a non-fiction, because the level of creativity is higher. Whereas the thinking with a non-fiction work there's less creativity, and therefore there's more margin for a fair use argument. Then there's a substantiality issue, and then importantly, this is the effect of the use upon the potential market for or value of the copyrighted work. So there's a very commercial angle you've got to look at when analysing whether or not the use is fair. Well, what does that mean? And I've got lots of examples. And what you should see when you see these examples is that it's really hard to call.
2 fingers.
And I think my conclusion is that it comes down to how good your lawyer is. This is I think it's a very sad case. So Associated Press did this picture with George Clooney and Obama, and then Shepard Fairey, the artist, cut George out, and created that. I mean, that's an iconic image. Everyone recognises that image. It was it became the defining image of the first Obama election. But he never got consent. He got sued by Associated Press because this made a fortune. He made millions on the back of that. T-shirts, posters, and Associated Press went after him. Now he could, I think he probably had a pretty credible fair use argument, because on a transformative basis, this was just a sort of a stock news image. This is an iconic. It's a screen print. It's a piece of art. He messed up though, because he
lied, right?
He lied. He falsified his books. He ended up going to prison for fraud because he falsified his books. And I think that influenced the court on fair use as well. I said, well,
he didn't actually go to prison though, right? Didn't he get some like?
He certainly got convicted of fraud.
Yeah, he did. But in the end, I think he was some sort of, I don't know. He didn't actually have to serve prison time. There's some deal, I believe.
What did he lie about?
He showed files. He said no, it wasn't from that picture. He was supposed to show the actual files that he used, and actually he gave the wrong files on purpose, and later admitted that he gave the wrong file just to show that actually no, it wasn't that picture. And later on they proved, well, actually no, the file you gave, you manipulated the evidence, and that's you
basically didn't have good enough law.
Yeah.
Well, but you also have to be very careful when you lie under an illegal
his
document.
lawyer would have advised him not to either, or not to.
But he thought he would get away with it a lot more easily by saying, "Oh, it's a totally different image. Here it is."
I can see the logic.
But surely, I mean, he's redrawn that, so I mean, you could have called that portrait, couldn't you?
Make it his property.
Yeah, that's why I think.
Wasn't what he got done for.
But for the well, no, but he also in the end, I mean, it was settled. It never went all the way. But having lied, it then became very difficult for him to say, but this is a fair use. Having been caught with his fingers in the till, for them to say, yeah, but it's still fair. He lost the moral argument.
Also, there's only technically that much of the picture in terms of the entire thing.
Yeah, but it's
percentages don't matter.
it's still the better half, isn't it? Sorry, but it is the better half.
It depends who you're talking to. Some people really love George Clooney.
So now we come to Jeff Koons. So there's a whole load of cases. So Jeff Koons has made it his life's work to parody, hasn't he? I mean, that's what he does. So this is 1992. This is a work called The Bananity of Everyday Life. He created three of these. These are sculptures, and sold them for $367,000. And when he was sued, because he was sued by the photographer, he said, "This is a parody." And they said, "Well, what's it a parody of?" And they said, "Well," he said, it's a parody of society." And the court said, no, you've got to be parodying the work. You can't parody society. That's not fair.
Yeah, but that's a fair point though, because all his practice is based on that. He's an appropriation artist.
Yeah.
So that's what
Yeah,
he
I
does.
mean, it wasn't. I mean, he lost this one, but it wasn't without controversy, that case. And and there's good arguments on both sides. But you've got to feel sorry for this guy as well, who would have made a pittance on that. And he's made millions of dollars, and that's actually that underlines a lot of these cases. Let me have a look at the next one. This is another one which he lost. So this is a 1988 work. So it's an earlier work. This is Wild Boy and Puppy. I haven't got a price for this one. So interestingly, he ran the parody argument again and said, well, it's a parody on contemporary pop culture, which is a more credible. That's his argument, but actually in the evidence, what came out was the fact, because he doesn't do any of this. He has a team, and he comes up with the ideas, and he says, go off and get it. He never said, get me Odie from Garfield. He said, I just need a cute picture of a dog, go and find me one. He had never heard of Odie until the case came. So when that evidence came out, they said, well, you're not parodying pop culture. You didn't even know this was pop culture. So that argument failed, and that too was a copyright infringement. This one, ushering in banality again, 1993. This was I couldn't find the photograph this was based on, but it was based on a photograph. And again, his instructions. So Kuhn's instructions to the people who manufactured the work made continuous reference to the original photograph, and he kept saying, no, it needs to have that like in the photograph. And it was all that evidence which ended up causing the problem. So he lost that one as well. But don't worry, you don't have to worry about. Don't worry about Jeff Koons. He's all right. This is a work called Niagara from 2000. This shoe here, this pair of legs here, was cut out of this magazine entry. So he cut it out, pivoted a bit, and stuck it on here. And the photographer, this was a glossy fashion mag, the photographer sued him for copyright infringement. And it was there's no denying it. It's the same picture. It's a slavish. It's what we call a reprographic copy because it's a photocopy. But he won because this was a transformative work. So he'd taken it, but actually, in the context, this is a completely different kind of work from this one, and the courts were convinced that it was transformative and it served an entirely different purpose from that one. So he won that one. Now you're going to ask me, well, how's that different from the other puppies and the woman? Because that's a completely different work. I can't answer you. It's the nature of these fair use cases that they just befuddle me. This is Parody coming back to slap him in the face. His famous balloon dogs. This was a Canadian company. So he sold these on eBay. Did you know that he ended up selling balloon dogs on eBay, and they were going for $12,500. Appropriation artist suing people who appropriate his art. The irony was too much. It got to even him. This is the state of the art now in fair use in America. This is very recent, within the last couple of years. So this is a series of photographs taken by a photographer called Patrick Carew. Patrick Carew travelled around Jamaica and took lots of pictures of Rastafarians in their native environment, and it was black and white pictures. It's quite evocative, but it's an anthropological piece, really. Richard Prince, so big name American, again, appropriation artist, took a whole load of these pictures and then adapted them. This is the most blatant. Other ones were, he did other things. And some of it was quite sexual, so he overlaid it with pornography. But this one was probably the most blatant and obvious. You can see all it's done is he's blurred out the eyes and put an electric guitar on there. Now these things, Richard Prince is a huge name. He sold 8 pictures, a series of 8 went for $10,480,000. And a further 7 sold for a price of $8 million. So what does that mean? So that's on 15 images, he made something like $18 million just selling the photographs, the original photographs, without the copyright. These are just photographs. He sold them for maybe countless millions. Surprisingly, there's money. Where there's money, there's a claim. So there was litigation, and it was big litigation. It went through. So the initial, it was the Southern District of New York. They said it's not transformative because there's no social comment here. He's just taking the piss, really. It's jokey. It's not, and he never pretended that there was this. This wasn't a parody. He wasn't taking the mickey out of Rastafarian culture. He wouldn't do that. I don't know what the thinking was. I don't know what the art is, but that it wasn't parody. It got appealed, so he lost. So Richard Prince lost in the first instance. It went to appeal. And on the appeal, he won. They were found to be transformative. These are sort of reportage. These are sort of journalistic, anthropological pieces. This is high art, and for that, and it's different. It's the argument of a different market. And so on appeal, he won. It then got appealed again, because when you're talking about countless millions of pounds. It's worth it. You know, you go through, you get funding, and you go through because there's millions of pounds at stake. I mean, these are all value judgments. What was interesting is it then went up to a higher court, and at that point, so there was an appeal to the Supreme Court, and while that was happening, Richard Prince went off to a whole load of big name artist foundations like the Warhol Foundation and various other big name foundations, and got them to each write to the judge saying, you can't stop this from happening. This is fundamental to the way American art is going. If you find in favour of Carew, you will destroy a significant part of contemporary American art. It didn't get to appeal. It was settled. We'll never know what the terms are because it was confidential. I suspect millions of pounds, millions of dollars.
But the previous decision, when he won, I understand there were still a few pieces that he didn't win on.
You're right. You're right. So, and I think this one he didn't win on. I think this is one of the ones where it was quite clear what the answer was. But there are others which were a little more hanging in the balance.
He won at most of them.
Yeah, you're right. It wasn't. I completely simplified it. It was more complicated than that, and he did win on some, and it was only some of the pictures. He conceded, I think, on some of them, and then it was only on some of the others that it went to appeal and appeal and appeal.
The
So-
idea would be transformative because it opens to a different audience.
Yeah,
It's,
but it's really subjective, isn't it? I mean, and again, you've got to feel sorry for this guy who sees these pictures going for millions and millions and millions, and he would have had a publishing deal which maybe got him tens of thousands at best. And he
What about
watches
the guy in
them
the
open.
photo? Sorry, I thought about the
Oh,
guy in the
yeah,
photo.
If he knows.
More to the point.
Yeah, I bet they tracked him down. Actually, they would have because this was a big story in the press.
Well, that's an interesting question about that.
Yeah.
So what if we snap
Yeah.
a picture of somebody, a woman walking on the street?
Yeah.
She's in public. She's on the public thoroughfare. Amazing photo. I've taken it. And then we use it on a cover of multi-million copy bestseller, and she goes back and says, "Hey, that's me.
Yeah.
I didn't give you permission
Yeah. Well,
to use this."
so there's a can of worms for another day. That's not copyright. So copyright doesn't come into it.
No.
But
But
there's
in America, you've got First Amendment, right? It's your experience.
you've got image rights in the States, certainly, and even in the UK, there's a privacy angle. And there's various other things that creep in. There's advertising standards authority rules which say that
Similar but different.
if it's a famous person, then you've got to worry about is this an endorsement? And there was a big case last year with Rihanna on the on a Topshop T-shirt. Did you see that one?
Yeah.
She won that one. And then there is a privacy angle as well. If somebody's got an expectation of privacy walking down the road, which you kind of do, you don't expect to walk down the road and then find yourself on billboards up and down the country.
What if you're on the witness protection program?
So it's a different issue. It's not copyright, but it raises some tricky issues, which is why releases have a value.
Yeah.
I have a friend in the States who has a blog, I think it's still going, called Hot Chicks with Douchebags. And, it was very big for a while. And anyway, he wrote a book, and he took a lot of photos while he was in Vegas. He saw people partying at like pool parties and had perfect examples of hot chicks with douchebags. And a few of them sued him for doing that, but in America he was able to win, saying that that's just basically he's just telling it's his experience. That was First Amendment somehow. And there it was okay. I think it depends on the country, but in the States that was totally fine. If it's you and you're expressing, this is something you're just taking your reality somehow and sharing it. That's still you're just sharing your experience.
I mean, I get lost in the different because in some respects America's First Amendment, freedom of speech, and it's sacrosanct.
Yeah.
On the other hand, they've got strong image rights,
So it does get
which
complicated.
rub up against that to quite a significant degree. And how you plot, of course, between the two.
But he won. He won that those cases.
To use the images then.
Yeah. Because he was saying like they were out in public, they were partying, they're going wild. There was no privacy issue, So it's different if you're in a private home or something. But yeah.
Let's carry on. There's not much more. So, I mean, all that fair use stuff, that was all images, and I'm conscious that that's not your business, your text, but images, I'm guessing, do come into it to an extent. But, and Joe, you weren't that keen on
No,
the
it was just to make, I am keen on it, because obviously it all went through last week or this week or whatever, so it was just if there was enough time. So if there is, I think there is, and that people are interested in hearing that, yes, so please do.
So Google Books, I think is significant. So what you've got here is, I've found one of your books on Google Books, but you know how it works. There's kind of, if you go back, there were two elements to it. There's the fact that they digitized loads. Well, there's probably three elements. They digitized loads of stuff. They just took books and they just scanned the hell out of a whole load of books and put them on their servers. With some of those books, they then put almost the entire book or almost the entire book up on Google Books. And with others, they simply put a summary up there. So 3 things going on, which were challenged. 1, the wholesale scanning and storing on the servers. 2, putting it up there. 3, summarizing and putting it up there. So the Authors Guild of America, this goes right back to 2005, this litigation. The Authors Guild of America sued for massive copyright infringement. It was a class action. By 2008, 2009, I remember this happening. It had gone a really weird. It got really weird, the litigation, because the Google said, as part of the settlement, why doesn't the court allow us to do this on the basis that we will pay 63% of our revenues? We'll pay a $60 payment to each publisher, to each author, plus 63% of our revenues from each book. So they were effectively asking the court, and the court were kind of entertaining this, to create a court-sanctioned compulsory licensing scheme that was international in its scope, and it was opt-out. So what they said, they were good enough to say, if you don't want to, you can opt out of it, but if we don't hear from you, we'll assume that we're allowed to completely exploit your copyright. And that's how it went through. From about 2008, they were negotiating some sort of deal on those lines. To 2011, the court finally rejected that settlement, threw it out. And at that point, Google accepted that it wouldn't be able to do sort of wholesale reproduction without consent on Google Books. So they waved that bit away. But they still were digitizing books without consent, and they were still putting snippets up. So the litigation rolled on. By 2013, the district court had decided that Google doing that, so Google digitizing, keeping it secret, but then putting up the snippets, was a fair use. So they were allowed to do that. That was appealed in 2014. April 2015, the Second Circuit, one of the appeal courts, reaffirmed the decision and said, actually, no, that is fair use. And then December 2015, the Authors Guild appealed to the Supreme Court. Now, did you say that
there was something?
There was a decision.
There was a decision in favour of Google this week.
Again, so I've missed that.
Yeah.
So if they've found in favour of Google, which was likely because the previous 2 courts had, what that indicates is it's the summary.
Right, that's what I didn't understand. I was like, how can that?
The decision was the Supreme Court said that they would not see the appeal. I think
they would not see the appeal
by the writers of the guild,
Authors Guild.
The Authors Guild. So effectively saying the lower courts.
The 2 lower courts stand.
I hadn't realised it was in relation only to the summary, but still, Google are making a lot of money because they're advertising driven.
Well, exactly. The pay-per-click thing is still working there, and it's money on the back of books, and a lot. It's a lot of money. So you can see why there's a complaint there.
They're saying the public good of being able to find these books and these sentences.
That's the rub, and this is again. Although one of the things that was said in the earlier judgments is Google had put forward evidence that this was increasing the sale of books. So they were saying that on that economic argument, the last of the 4 factors in fair use, this wasn't hurting. This is actually helping the publishers.
Yeah, but isn't that beside the point? I mean, it's still a copyright issue, regardless of who's making the money.
Yeah, but remember that copyright, you've always got this tension between the rights of the author and the rights of society at large. And actually, if you look at, I mean, Google's entire business model is based on summaries of stuff. If they'd have
It's
lost,
very different than an entire book scanned in without
They can't-
permission.
no, but
No,
they
but
can't,
you
do
can't
that.
read the whole book through Google Books without
But they
paying.
still have it
You,
scanned.
They have it. They
yes,
have
but,
a
you,
copy
but you
scan.
can't just see it. It's not like someone you can basically look into a particular page and see
Exactly.
find a
Yeah,
sentence.
I'm not
You
talking
can't
about
see
me,
the
I'm
whole
talking
book.
about Google making
So
that
do
copy.
Amazon.
Yeah,
So do Amazon.
but Amazon, so Google do that, but they only do it to enable the summary to be created. They don't make that scan available. That's a single scan that's locked down on their servers. They don't make that available to public. They just make the summary available. And had they have lost, it would have called into question the entire Google search engine, because that's what it does to websites as well. Remember,
Yeah.
it summarizes the first 3 lines. If they'd have lost on books, what does that mean for Google? And actually, I suspect that the courts had that in mind. That how is the world going to survive without search? You know, that we would grind to a halt, wouldn't we? So they probably had half an eye on that as a policy decision, that they couldn't kill Google.
But they would have, I mean, Google would have known before they scanned all this work in that that was against copyright. I mean, they wouldn't have just done it without any,
But-
I mean, they probably got
Yeah.
But it's different. But
massive
the
legal
scanning, it's not the copying necessarily. Obviously it's the sharing the copy that's illegal, right? So even though you're not supposed to copy technically,
Yeah.
it's only when you actually share it
Yeah.
that you're breaking the law.
But they're saying that the whole scale scanning, but keeping it unavailable, that falls within the fair use defense.
Yeah.
Really, and they got away with that.
Yeah.
Well, yeah, but like if you were to Xerox a book and keep it under your bed, nobody's going to come after you.
Yeah. Technically, there's an infringement, and actually, but yeah,
It's like when you take a photo of a recipe.
yeah.
But if you start sharing it and giving it to
I'm
people,
not a multi-million-pound global company which has, probably teams of copyright lawyers, I would imagine.
Okay, so let me ask you this question: what's the appropriate damage? What damage does the author suffer in consequence of Google having scanned it and put a summary on its website? What?
Is that what they would argue then, not the fact that they shouldn't have copied it in the first
Yeah,
place?
the fourth factor when determining fair use is: are you doing something which competes with the business interests of the author? And the answer to that question in Google is probably not.
Which is exactly what's in our contracts. It's not that the idea is the author's idea that they are not allowed to do something that will compete with the sale, I guess, of our that they've given us the copyright on for it.
Yeah. I mean, it's complex, and and I'm putting my hands up. Remember my first slide? This is an imperfect system.
I see your unease on it, because I mean that's why although we agreed with search and such
Exactly.
for Amazon,
Exactly.
we actually have agreed to give them
Exactly.
the whole of the book
Yeah.
digitally, with them
Yeah.
saying,
Yeah.
but what if they become even more dominant? They say, well,
Exactly.
guess what? The only way we sell ebooks is
Through
through us, and
yeah.
guess what? We have the files.
Yeah.
Yeah, but I'm
Guess
sure
what?
they
If you
start.
don't agree to it, we're
I
not going to
just
sell
don't
books anymore.
think that they
Which they've
ever
done
have
before,
anyone in their
haven't
best interest other than themselves. It's all about money for them, isn't it? It's not about.
Yeah.
Yeah, but I mean, they've got so much money that they don't really care about anyone else anyway. Really.
well,
So
they still
they
have to
do it,
abide.
but it
They still have to
gives them carte
abide
blanche
by
if they
regulation and law. Like Google is changing a lot because of EU regulation now, right? Like their whole search is completely changed in the EU recently.
But it is
They
a
do
balance.
take the mickey. I mean, what they do is that they stretch, they push till they get pushback, then they change.
Yeah.
That's what, and they've always done that. And actually, everybody does. That's what Amazon do. That's what all disruptive businesses
We
do.
publish books that say we've made every possible effort to find the copyright or the permissions holder or whatever it is. We do it ourselves. We do.
We try.
Yeah. Exactly.
2 more slides. So let's so we've
That was
been
good.
through that
Sorry.
one. So let's go down to the copyright and copyright issues. I just thought I'd summarise a couple a couple of issues here that come up in contract. I put down this idea of license versus permission. What's the difference between a license versus a permission? If you were to say to somebody, I mean, you know what a license is. It's a nicely drawn up contract that says we're allowed to, in the context of your authors, we're allowed to use your literary works for these purposes, and in return we'll give you this, but you keep this. You know, nicely sits the things out. What's the difference between that and a permission? What's the difference between that and you calling up the author and saying, can we publish your book? Or you putting an email, they send me an email back saying, yeah, you can publish our book. The latter is a permission, and the risk around a permission is that if you ever get challenged on it in court, the court will recognise permission, but they will interpret it as narrowly as they can. So you say, can we publish the book? And they say yes. You then publish the book, and then then you try and publish it overseas, and they say, oh no, I never said you could publish it overseas. You end up in court, and the judge is likely to say, well, when you say you were publishing the book, he didn't think you were publishing it overseas, so you haven't got the right to publish it overseas. So tough, you know, and down to the, you know, you might get a permission to use an image. So you say, can I use your image? And the person says, yeah, that's fine. You can use it in front of my book, on the front of your book. You use it, and then 6 months later you get an invoice in the post. And you say, but you said I could use it. And they say, yeah, but we didn't say we weren't going to charge for it. So the point is, use licenses which set out what you can and can't do, and set out what you're going to give back. Don't rely on permissions, because permissions, unless you really tie down the permission, you're going to get in trouble. When you're doing a license, I mean, I'm sure I'm preaching to the converted here. You've got to understand between exclusivity and non-exclusivity. That will tie in with territory, which we'll come to in a minute. But you want exclusive rights. Of course, you want exclusive rights. It may be time limited, your exclusivity. It may be format limited, but you need a degree of exclusivity. Otherwise, you're going to find yourself competing with either the author or another publisher. Term and termination triggers. A10 and I had fun with the termination triggers in the past, but just keep an eye on on the bit of the contract which says this agreement terminates in the event of. Because if you get that wrong, you could end up, particularly around insolvency, you could end up losing the contract at a pretty early stage, when you actually need, when you're still trading, but you're in financial difficulty. So you want to make sure it's clear that you don't lose the licenses that become terminable until quite far down the line. Territory, just, you know, I think that stands to reason. Just make sure that you've got the territory that you need. And I've got scope of rights granted as a thing there as well. And that's about formats. That's making sure that you've got the right to do it in as many formats as you can conceive and as many future formats as you can imagine. And I put down moral rights. Is it really clear what moral rights are? The moral rights they're like copyright, but we've had them since 1988 in this country, but we imported the idea from the continent, where France has had them for many years. There are 3 important moral rights. One is called the right to paternity. And the right to paternity is that the author has a right to be recognised as the author of the work. Now, that's not normally a problem, except in the context of ghostwriting. Where it can be a problem is if somebody asserts their right to paternity, and you have to acknowledge them, where you've got a sort of a compilation. It gets quite tricky having to do it. If you've got the kind of work where you've got multiple people contributing to it, think about getting the author to waive their moral rights, because the author can waive them. But generally, I don't think it's a problem. I think you will, as a business, you will recognise the right of the author to be identified as the author of the work. The second important moral right you need to be aware of is the right to object to derogatory treatment of your work. So an author has the right, even if they've assigned copyright, they have the right to object to a derogatory treatment. Now, what does that mean? You've got to be careful, because it could mean an edit of their work they don't like. If they can argue that you've edited it in such a way that it's now it's corrupted and it's no longer recognisable as, and it's not the same work that they created, technically they've got the right that they could cause you problems. So you can, that's another right that you can waive, and most publishing contracts have a waiver of the right to derogatory treatment. And then the final one is false attribution. So the right for somebody not to be falsely for me to complain if my name is put in the book that I've got nothing to do. There's another one which you don't need to, which doesn't come up much, which is privacy in private photographs. So if it comes up with like wedding photographs, you commission your wedding photographer to create photographs. The photographer will own the copyright, and that's how they make their money. But they are not allowed to exploit, where it's a private commission, they're not allowed to exploit those photographs commercially without you saying so. Don't think that's going to be relevant to you. So it's those three. It's the paternity, derogatory treatment, false attribution. Just make sure they're covered off in the contract. The final thing I had on that slide was infringements. And the question there is, if the work is plagiarized, who is it that's A, responsible, and B, entitled to sue? And you've got to think carefully about those two questions, because there may be situations where you think, yeah, we definitely want to have that right, and that's fine, but try not to accept an obligation to enforce, because that can be really expensive. You know, if you find out that the book's being infringed in China, you know, good luck trying to stop that from happening. It's going to cost you a fortune, and you might not get anywhere. And if you've got a contractual obligation to enforce, that can cost you a lot of money. So the answer there is to try and get the right, but not an obligation to enforce. I think I might call it a day there, unless anybody's got any questions. My voice is going.
That was great. First, let's give Anthony another round of applause. I think that was fantastic. I mean, let's a few questions, I guess. Yeah.